Good evening, and welcome to Chesapeake Public Schools Family Empowerment Webinar, presented by the Office of Family and Community Engagement, or FACE, and the Office of Exceptional Learning. I am Eunice Brown, one of the FACE specialists. Joining me tonight is my FACE colleague, Lisa Carey. I would also like to acknowledge Elena Trott, Director of Strategic Planning and Partnerships, Dr. Craig Pinello, Director of Exceptional Learning, and Dr. Lisa Perkins, Assistant Director of Exceptional Learning. Tonight, we have with us Chesapeake Public Schools Transition Specialist, Frankie Dampier-Nichols, Dampier, Transition Specialist, Great Bridge High, Hickory High, Great Bridge Middle, Hickory Middle, and Chesapeake CSAP. Christina Trinella, Transition Specialist for Western Branch High, Western Branch Middle, Jolliffe Middle, Chesapeake Career Center, and Chesapeake Center for Student Success. And Sharon Willis, Transition Specialist for Grassfield High, Deep Creek High, Hugo Owens Middle, Deep Creek Middle, Crestwood Middle, and Greenbrier Middle. The goal of transition planning is to prepare students with disabilities for life after high school. All students receiving special education services, including speech services, need assistance in their transition to life after graduation. Transition planning begins no later than grade 9 or age 14, whichever comes first. For more information, contact your special education transition specialist. We have put all of their information, we'll have all of their information for you. Our office equips to inspire, engage, and empower families, educators, and agencies to collaboratively partner in supporting the mission of Chesapeake Public Schools. We are available Monday through Friday by appointment only due to current COVID restrictions. We have several upcoming programs that may be of interest to you. Information for our programs is advertised through Peach Jar, Twitter, Chesapeake Public, and the Chesapeake Public Schools website. On April 15, we will start kick off our series for 4-H before we close for the summer. Tomorrow, get your shovels. Next week, get your shovels and gloves ready because our presenter will provide some tips on gardening with our kids. On April 21st, 2021, as part of our recognition of the month of the military child, we will host a webinar on charting the course, resources, and supports for military families. On April 22nd, we will host our third installment of Let's Talk, Race and Cultural Diversity series. Our topic of discussion will be how to foster multicultural experiences with our children. Dr. Ken Westcott will join us again on April 27th for another powerful discussion on vision therapy with children with autism. And finally, on April 29th, we will have our final presentation collaboration with the Parent Resource Centers in Region 2 for the school year. Our topic for the evening will be waivers for children with special needs. All webinars will start promptly at 6:30, unless otherwise noted. Tonight's webinar will be recorded and placed on the Chesapeake Public Schools YouTube channel in the next several days. At this time, I'm turning the program over to Dr. Frankie Dampier, who will present the speakers for this evening. Before I do, I would like to remind the audience that if you have any questions that you would like answered, please put them in the Q&A box and our presenters will answer them at the end of the presentation. Frankie?
Good evening. I have the pleasure of introducing to you tonight our two presenters. We have Ms. Shannon Lehman-Pecoraro, who is a shareholder of Hook Law Center. She is practicing in the area of elder law, special needs planning, estate and trust administration, estate planning, asset protection planning, financial planning, guardianships, and conservatorships. Ms. Lehman-Pecoraro is certified as an elder law attorney by the National Elder Law Foundation. There are only about 500 certified elder law certified attorneys nationwide. Prior to joining the firm in 2012, Ms. Lehman-Pecoraro handled estate planning documents for the members of the United States Department of the Army and has been involved in the legal representation of several large corporations. I also have the honor of introducing to you Ms. Donna Roble, who is the Southwest Hampton Roads Regional Network Coordinator for the Center for Family Involvement at Virginia Commonwealth University. Donna's passion for advocacy took center stage in 2004 when her daughter, Elena, was born with Down syndrome. Soon after Elena's birth, Donna started mentoring other families within the disability community. She is a 2014 graduate of the Virginia Board for People with Disabilities Partners in Policy program. A Hampton Roads native, Donna does live in Virginia Beach, and I am very honored to welcome both of them to be here this evening to share this very valuable information with you. So I will now turn it over to Ms. Lehman-Pecoraro.
Hi. So today we are going to be talking about what do you actually need to know about planning for the future with regards to surrogate decision making, and then also for yourself, what kind of things you need to take into consideration as you plan the future for your loved ones, and particularly whenever you're not here. So when we talk about special needs planning, oftentimes people look to, just there's a trust. So a lot of my clients come in and they say, I know that I need to look at special needs trusts. But the planning actually does involve a lot more than just a trust. It often involves looking at what public benefits may be available to help support an individual, looking at what tax laws, there's certain benefits with regards to various tax laws that are in place right now. And then also understanding kind of the financial ramifications of everything. Sometimes we look at also, what does the personal care planning situation look like? How do we transition somebody to maybe a more independent living situation, or plan for an event that maybe you're not around for? And then also make sure that whatever the plan is, that it is properly supported with appropriate financing. So what are my clients' number one concerns, or any family's primary concerns? How do we plan for a disability? So this could be for your individual child's disability, but it could also be for your own. Also, what housing options are available? Or is your child going to remain with you for the remainder of their life, or do we want to provide some sort of other setting? How are we going to pay for any long-term care that may arise, whether it be your own or your child's? What assistance is available to help cover the cost of such care? Regular tax and estate planning, which we all need. The second we turn age 18, I just had a conversation with a Chesapeake student actually earlier today with that regard. And then also, what are the duties and obligations that you have to an individual that you might be serving as a fiduciary for? And I'll go into more about what a fiduciary is later. And then how do we maintain public benefits eligibility so that we're not destroying it with an inheritance or a gift, something like that? And then also, what is available for caregivers in terms of support? All right, so first things first, a lot of people do not understand public benefits in general. So on the left-hand column, we have what are called financial need-based or asset-based programs. And then on the right-hand side, we have your assets that your programs that you're eligible for just based on certain eligibility criteria that does not look at financial means. So for the vast majority of my families, what we're going to be looking at is supplemental security income, or termed SSI, and then the Medicaid programs. There is what's called a veteran's pension benefit, and that can be advantageous when there's a military connection. We might also look at something like food stamps or legal aid, housing subsidies, and probably the number one benefit in Virginia, and I'm glad to see that it will be talked about later this month, is that the waiver services. So for those of you that are not familiar with the My Life, My Community programs, formerly known as the IDDD waiver programs, those are probably the most critical benefits in setting up a transition plan whenever a family is not able to provide the support any longer. Understanding that getting those turned on even sooner is normally better for the family too, but it's essentially critical whenever a family member is no longer around. Then you look at the Social Security system for the non-financial needs based. You're looking at regular Social Security or even Social Security disability income. So this becomes really important because if you have a disability determination prior to age 22, you may actually switch from the SSI system where they're looking at assets and your own personal income into the work record of your parent and be able to increase your disability benefits. Okay, so supplemental security income, in order to meet the eligibility criteria, you must be disabled as defined by the Social Security Administration. The definition is that you have to be unable to maintain substantial gainful employment, which basically means that due to some sort of physical or mental impairment that's expected to last for 12 months, basically there's no job you're going to be able to hold down that you're going to maintain what they consider the substantial gainful activity amount. Right now, it's roughly about $1,200 a month. So if you're unable to earn that, then you're not able to maintain substantial gainful employment. Additionally, in order to qualify, your assets must be below 2,000. And then there is this funny little income test that we'll get into on the next slide. The important concept of SSI is to understand that the sole purpose of SSI is for food or shelter and nothing more. So Social Security essentially says, well, it's not our job to make sure that you have food or to make sure that you have shoes on your feet or clothes on your back or those video games you may have wanted, but we really need to make sure that there's a roof over your head and food on the table. Prior to age 18, a parent's income will be what's called deemed down to the child. After age 18, that parental duty of support goes away. And as a result, a lot of my clients, their family member may become eligible at the age of 18 when they were previously denied because of the family's total income. So there is what's called an in-kind support and maintenance rule under the Social Security system. And so this is one problem that as a practitioner, I see happen quite frequently. If you go back to the premise of SSI is for the sole purpose of food and shelter, essentially what Social Security says is if you are not paying your fair share, then you might be subject to a reduction because obviously you don't need all of our money anymore. And so depending on the circumstances of the family, you might see a 1/3 reduction or one-third plus $20 reduction. And so a lot of times when families come in and I see some sort of reduction from the full amount, which is currently $794, this is the first thing I look for. And essentially, if mom and dad aren't charging rent, that's where the problem lies. So there's some planning we can do there. The other thing is that if I have an individual that's working, then I might see a 50 cents on the dollar reduction after what's called, it's a $65 disregard for earned income. So first $65 is ignored, and then it's 50 cents on the dollar for every dollar earned that your SSI is going to be reduced. And then you have an unearned income reduction that they disregard the first $20 for, and then it's an actual dollar for dollar reduction. So this is going to be in cases, I do a lot of personal injury consulting. And so this could be in the event that you have a structured settlement saying paying $500 a month, what will actually happen is that they'll disregard the first $20 of that monthly payment and then reduce your SSI benefits by $480. You will completely lose SSI benefits if you have asset accumulation of over $2,000 in a given month, and then the gross earnings over 1310, I said it was about 1,200. I have to always round right now because they change every year. So gross earnings over 1,310 in a month, and then if you're blind, it actually has increased to 2,190 in a month. All right, so we talked about the $2,000 asset limit. So if you can convert an asset into cash, essentially it's going to be countable. And what they're looking at is, are you over $2,000 on the first calendar day of the month? So, and they're going to exclude the income they may have hit that first day. There are some exceptions that are going to apply, and that's going to be a principal residence. They will disregard your primary residence, tangible personal property inside the house, one car, a prepaid burial, some life insurance, and this is going to be anything that does not accumulate a cash value. So this will be either a term life policy, or it could be a group life policy through like VGLI or the service member group life policy, something like that. and then an ABLE account, which we'll get into in a little bit. The most important thing that I tell my families is that an inheritance is going to cause a problem. If you are on SSI and you lump sum anything out to your child, then what's going to happen is that inheritance will be a lump sum to them. It's an asset. It will be counted against them if not in a special needs trust. So these are the other Social Security benefits I'm going to lightly touch on. And essentially you have your regular retirement benefits. There's no asset criteria for that. You're going to have your SSDI, which is based on your own work requirement. And then you have dependent and survivor benefits. And so for the purpose of this presentation, those are the most important. If your child was determined to be disabled prior to age 22, then when you either retire or become disabled yourself, then your child would actually be entitled to up to 1/2 of your benefit. The other nice thing is that in the event of your death, then your child would actually be eligible for up to 75% of the benefits that you were able to collect. So that disability determination prior to age 22 is very critical for the long-term success of your child. All right, so this is a hypothetical, and I keep building on this hypothetical as we're going through. But essentially, let's say John's receiving $794 a month of SSI. So that's the full monthly amount right now. John's father, Joe, retires, and now he receives $1,400 a month. So John's father, Joe, receives $1,400 per month. What'll happen is Joe's going to actually receive $700 per month in Social Security. So what's going to happen is that's an unearned income. And so SSI is going to actually be reduced by $680. So $20 disregard, and then a dollar for dollar reduction. So John is actually going to continue to receive SSI of $114 a month. And then he will also receive the $700 from Social Security. All right, so Medicaid, traditionally, there have been 2 Medicaid programs around the country, really. You have your CHIPS, which is your Children Health Insurance Program. And so that's throughout categories. And then you have what was called ABD, or Age Blind Disabled Medicaid. Your Age Blind Disabled Medicaid is the one that's asset tested, whereas CHIPS is only income tested. You also then have your waiver programs, and how I explain to clients with regards to what waiver programs are is essentially your right to care is in a facility setting. So in the hospital, nursing homes considered a facility setting. If you're going to receive care outside of those traditional settings, what it actually is you're waiving your right to care in the facility. And so that's what kind of essentially then builds out these waiver systems. As long as you're receiving $1 of SSI, you're automatically eligible for Medicaid coverage. And in Medicaid, when we're looking at either the waiver programs or the ABD programs, we are still going to have that resource limit of $2,000. So I do have some families who are like, well, I don't care about the SSI as much, but the Medicaid waiver programs in particular are kind of those paramount programs that we want to protect. All right, so why are the waiver programs? And if you sit in on the presentation that's going to be coming up by the end of the month, this explains why the waiver programs are so coveted and why it takes so long to get on them, for those of you who are familiar with the waiver waiting list. If you look at who's enrolled in ABD Medicaid, it roughly amounts to a little over 20%. The rest are for caregivers, children, pregnant women, that CHIPS category we talked about. However, when you look at total Medicaid dollars spent, it actually accounts for about 75% of total Medicaid dollars. And so as a result, the long-term care costs associated with things, that in-home attendant care, the waiver programs, that's what actually is the most expensive part of the Medicaid program. And so that's why we see a limited number of slots. So this is always a good slide, I think, just for people to see in terms of why do we have this waiver waiting list? What's that cost of care? And it really is just a very small percentage of the population in terms of total Medicaid population uses a lot of Medicaid dollars as a result of the expensive care that they're receiving. Effective, I think it was January 2019 now, time flies, we now have expanded Medicaid coverage in Virginia. And so if your child doesn't necessarily need the long-term care support services or the waiver programs, but you're worried about just traditional health insurance, expanded Medicaid coverage now bridges the gap from the CHIPS program to the ABD program. So age 65, you're presumed to be disabled. And so that's why it's age blind disabled. And so now what happens is, as long as your income is under the 138% poverty level limit, then you are actually eligible for Medicaid as long as you don't have another source of health insurance. So for instance, if I was under this limit, my husband is active duty military, I get TRICARE, they wouldn't give it to me because I do have another health insurance program available. So this is really to bridge the gap between age 18 and age 65. And it's all income based. It's not going to be asset based. So this is a nice little program that some of my clients look to for a continuation of health insurance. We also have the Affordable Care Act. So in the event we're over that 138% of the poverty level, then we can look to the marketplace. There's no long-term care services under here. And so we still have to look under the Medicaid program for any of those services. But there's 4 levels of coverages. There's open enrollment periods. And this was really important before certain states expanded Medicaid. And if you are going to relocate, because we're in a highly transient community, it's important to know what states you may or may not have Medicaid expansion in, because it's not something that was adopted nationally. What are some other benefits? So Section 8 housing is a benefit that we often look to whenever we're looking to various types of planning. Depending on income, we may be able to get food stamps to subsidize some of the food-related costs. Legal aid is a free legal service available. They do have limited services, but that's going to be an income tested program as well. And then we do have some various utility assistance programs to help with a successful transition for a child into the community. All right, so what are some of the pitfalls that I see with clients whenever they're planning for a disability? And this could be for an elderly person, this could be for a child. This is going to be child support. Payments of child support are actually the child's income. And so that is considered an unearned income when we're looking at public benefits. Even if it's paid to the mom, it doesn't, or dad, it doesn't matter. It's still that child's income. Gift to minors accounts. So there's these UTMA accounts that you can hold money now, actually under law, you can actually hold it until age 25. Those are countable resources because they can be used basically for the support of that child. And so as a result, those are going to be counted. 529 education accounts, those you can withdraw the funds from them. And so even though there's a penalty associated with it, our public benefits programs don't care about that penalty. What they care about is, can you access it to pay for something? So 529 education accounts are going to be problematic. I just met with a lady earlier today, and instead of naming her son's special needs trust as the beneficiary, she actually named her son as the beneficiary. And so not having something go to where it's supposed to go can be a problem. Disinheriting your child. Whenever I first started, I used to hear a lot, well, I'm just going to give everything over to my child, my other child, and they'll have the duty to take care of their sibling. That's all fine and dandy until that child dies, they get married, and let's say the wife doesn't, or husband, whoever, thinks that they need to have access to that money and not necessarily take care of the other child. It creates a moral obligation, but not a legal obligation. That child also goes and gets into some sort of creditor problem, has to file bankruptcy, or otherwise maybe gets in a car accident. That money could all be subject to the claim of that other child's creditors, and as a result, not be available for that support that you intended it for. Not using the proper trust. So I do see special needs trusts that are improperly drafted by other attorneys in the area. And in that event, we have to use what is called a decanting process so that we can properly move it from the invalid trust into a valid trust and maintain public benefits eligibility. And then the number one problem is no planning. So Andy Hook often says that failing to plan is actually planning to fail. And so we do have clients that I say do what's called the ostrich effect. They kind of dig their head in the sand and they just we'll figure it out later on down the road. But not planning obviously sets things up for failure. All right, so what should you consider? And this is all going to be about you as the parent of the child. Making sure that you have a good power of attorney. I often tell people that a power of attorney is not a form. So while you might be able to get a document online, that may not give you all the power that you wanted to be able to do certain things. We have what are called hot powers here in Virginia. And unless the power of attorney specifically authorizes certain things, you can't do it. So one of those things would be providing support to a dependent child. So whenever I'm meeting with a family that has a member with special needs, it's important that I put that in there so that whatever support you are currently giving that child can maintain. Absent that, your agent's hands are going to be restricted in doing anything that isn't otherwise for your benefit. Also making sure that you have proper wills and trusts put in place and not providing outright gifts. Those outright gifts, as I said, are going to disrupt any public benefits that are means tested. And so we want to try and avoid that. Then make sure all the assets that you're leaving actually flow into that special needs trust. And then also we have some retirement benefits issues. We once again, instead of naming the individual as the beneficiary, we need to make sure that the trust itself is identified as the beneficiary. What are some basic planning tools then that we look at? And we're going to go into each of these, so we'll go ahead and fast forward. All right, so when we're talking about surrogate decision making, so who's going to be able to actually make decisions for you or for your child? The first thing is that I have to look at capacity, and we are all presumed to have capacity at age 18. And it's interesting because I often have families that come in that are like, what do you mean that my child who, basically their testing scores are coming back that they remained in second grade? What do you mean I can't make decisions for them anymore? We're all presumed to have capacity at age 18. And so what we have to look at then is, does somebody actually have legal capacity? Whenever I'm looking at that for what's called a power of attorney or advance directive, the underlying question is does the individual understand the nature and effect of the document? So can I actually sit down and explain to that child or adult that this document will empower somebody else to be able to make decisions for you, and then kind of build out from there? The power of attorney or advance directive are documents that are going to empower you to elect a person to make decisions on your behalf. The good news is that there's no accountings associated with these unless you actually want there to be. There's no surety bonds. And what a surety bond is basically an insurance policy that says, in the event that something is mismanaged, this insurance company will pay the money back into the estate, and then they'll come after whoever the fiduciary was that mismanaged something. And then you have your representative payee process. Go back to civics class, separation of federal and state government. Anything not expressly reserved for the federal government is actually a creature of the state. So I've read a lot of federal law, and powers of attorney are not in there, guardianships are not in there. And as a result, those are state creatures. So when you're looking at things like Social Security or even DFAS or OPM, those are all federal income sources. And so they do not respect powers of attorney. They do not respect guardianships and conservatorships. So power of attorney, the fundamental question is, does somebody understand these documents? Power of attorney is going to allow for financial decision-making, whereas the advanced medical directive will allow you to make those personal decisions, those medical decisions. Guardianship and conservatorship is actually the same thing, but basically the individual didn't have the requisite capacity to make the decision to appoint somebody themselves. Guardian is the person that's going to make those personal decisions. The conservator is the one that will make any financial decisions. The judge will determine that the individual is incapacitated, and the court's going to decide who's going to be appointed. And so somebody that you may have wanted appointed, if they have filed a bankruptcy, they may be excluded from handling somebody else's finances, even though you trust them. And similarly, if there's a history of domestic violence or something like that, then the judge may say, I'm sorry, but you have these charges. And as a result, we're not going to appoint you a guardian and making personal decisions over somebody else. The conservator will be required to file annual accountings with the court, actually with what's called the Commissioner of Accounts, who will then report it to the court. And there will actually be an annual requirement to report the guardianship activities to Department of Human Services as well. And basically, if the court is appointing somebody, they want oversight. They want documentation that the guardian and conservator is doing what they're supposed to be doing. There'll be a required surety bond, and that surety bond, once again, is if that fiduciary doesn't do what they're supposed to do, especially in the conservatorship arena, then the money will get put back into the estate, and then the insurance company will go after the fiduciary who mismanaged the money. We still have the representative payee issue because, once again, guardianship conservatorship is a creature of state law, not federal law. When I'm assessing capacity, and actually my last appointment of the day, this is actually what we were discussing. And the fundamental question is does somebody understand what they're doing? We do oftentimes want to address this outside of the presence of family and agents. I can keep a family member in there if the individual is more comfortable with that, but usually I have to tell whoever else is in the room they're not allowed to talk or answer the questions for the individual. I really need to make sure that the individual understands what's going on. We are, as attorneys, documenting capacity. So we will have witnesses, we will have memorandums, we will have notes, so that if there's ever a question, we can say, this is what we observed. Anytime we question, because we do unfortunately get into gray areas, and I always say a diagnosis alone is not sufficient to determine whether or not somebody is incapacitated. So I have people who are diagnosed with dementia on a regular basis. That does not mean they still can't execute documents. But if I've met with somebody and I'm just not like, it falls in this gray area, or there's some underlying concern with the family dynamics, we will get a physician to opine whether or not the individual does have requisite capacity to execute the documents. So durable power of attorney, I've kind of touched on it already, but it does create what's called a fiduciary relationship. And what that fiduciary relationship means is that you can be held accountable for your actions. So you have certain duties and obligations to your principal when you are serving as an agent. So you act up, you don't do what you're supposed to do, you can be sued for it. It is a grant of authority to make financial decisions, and it's going to survive incapacity. The terms of the document itself is what governs the authority that you have. And so there is a line in most powers of attorney that says, and my agent can do anything I otherwise would be able to do. Unfortunately, that's not the case. I have already said we do have these hot powers, and without those hot powers in there, you're not going to actually be able to carry out those powers. So once again, this thing is not just a form. Advanced directive. This is going to actually consist of two pieces. So it's going to contain your living will, which is going to outline really what you want to have happen if you have a terminal condition or in a persistent vegetative state. Do you want machines artificially prolonging the dying process? And then do you want artificial food and hydration giving under those circumstances? And then this document will also appoint an agent to make medical decisions when you can't make it. Now, I do often have times where people want to be able to make decisions immediately. The problem is that we never want somebody to usurp our power to make our own decisions for our own person. And so as a result, the law actually specifically says that you cannot actually be an effective medical agent unless a doctor determines, and it's actually two under the law, determines that you're incapable of making an informed decision. And so we can't really get around that. That's the law. And I always use like chemo as an example. You've had cancer once, you decide the second time, whenever it comes back, you just don't want to go through the chemo and the radiation anymore. That's really your decision to make. It's not for anybody else to decide. These things should be prepared in the state that you're currently living in, to the extent that it can be updated. And that's just because the medical laws vary so drastically from state to state. All right, guardianship conservatorship, as I already said, guardian of the person, residence, medical, education, and employment. Conservatorship of the state is going to be all financial decisions. And this is going to be required if somebody is incapacitated. I've already talked about the filing requirements, qualification. As I said, we're going to look at, do you have any felony offenses or bankruptcies, because the court's not going to necessarily trust you in those circumstances. And then we have these bonding issues. And then for some acts, such as those hot powers under a power of attorney, or even just moving somebody out of state, Virginia Beach residents in particular have a very difficult time because the court wants to know when you're moving them and where you're moving them. So I can't get pre-approval to just allow somebody to move somebody out of state in Virginia Beach. Chesapeake's a little bit more flexible. But so certain acts I am going to actually have to ask express permission from the court for. All right, so we get to the fun stuff. What is a trust? So fundamentally, a trust is actually a bifurcation of legal title. And so what that means is that the trustee has legal title, meaning that they have the legal ownership of it. They get to control the management of it. And then you have beneficial title. And so that's for whom the benefit is created for, the benefit, who gets the benefit of having the trust. The trust is really just a contract that's going to govern the control of that property. Special needs trusts in particular have to be drafted in a way so that public benefits can't look at them. And the key words in there are going to be wholly discretionary, and that they have to be used to supplement and not supplant public benefits. So that way public benefits programs can't say, oh, well, this can be used for health, education, maintenance, support, so you have to use this first. All right, so a lot of people have heard of special needs trusts, but maybe not know that there's multiple kinds. We break them down into two major categories. The first one is self-settled, and the second one's third party. So self-settled means that it's from the assets of the individual themselves. A third party means that they're receiving it from somewhere else. And in the self-settled arena, we have what are called D4A, which are standalone trusts, and then your D4C trusts, which are pooled. They're managed by a nonprofit organization. And so in the third party arena, we once again have a standalone or pool, just no code sections to govern those. And then for the standalone trust for a special needs, third party special needs trust, we can make them what are called inter vivos, meaning that they're alive while you're alive, or testamentary, meaning that they fall under your will. And so they only become effective at your death. I'm not going to go into every line of this, but there are some tax consequences over different things. And then also, whether something's revocable, irrevocable. The big thing to know, and this is what my families worry about the most, is first party special needs trust can only be set up by the individual themselves, a parent, a grandparent, a guardian, or the court. They have to be established for a person with a disability, no ifs, ands, or buts. They have to be funded prior to age 26, which means if they receive any money after age 65, or did I say 26? Sorry, after age 65, then that money basically can invalidate the special needs trust. And the thing that people hate the most is that there's what I call the you can't have your cake and eat it too rule. And what it is, it's a Medicaid payback. And so essentially, if this was my money, and I do a lot of personal injury planning around the country, they essentially say, look, you can get $1 million from your personal injury settlement, squirrel it away, use it for the benefit during your lifetime. But at the end of the day, because of those high costs associated with, in particular, like the Medicaid waivers and the long-term care costs, you can't have your cake and eat it too. Medicaid is going to get repaid back up to the extent to which they've paid for medical expenses on your behalf. Now, this is a lifetime thing. It is not from the date in which this trust was established. So certain programs like special education sometimes are funded through the Medicaid program. And so that will build on whatever that Medicaid payback is as well. And so that's just a little thing that a lot of families don't realize. Third party arena, you have no obligation to give anybody any money. And as a result, those rules kind of go out the window. There's no Medicaid payback. There's no age limit on these things. They can be created during your lifetime or at your death, or you can be the trustee during your lifetime if you create during life. So there's a lot more flexibility there for my families. How do we fund special needs trusts? So life insurance is probably one of the number one ways that we do this. Housing options. So in particular, if you want your child to remain in the home, we can talk about, how's that going to be maintained? Does it just go to that individual child so that the other child, if they want to live there, they have some sort of obligation, they can't force the sale, stuff like that. Obviously, the cash or investments you may have, child support payments have to go into a first party special needs trust subject to that Medicaid payback because it's the individual's income. Retirement plans also can go in here. And it's very important to talk about the tax consequences. Unfortunately, not all attorneys fully understand taxes. And unfortunately, tax deadlines are tomorrow for fiduciary income tax returns. So it's been a little chaotic in the office because we do heavy taxes. But it is important to understand that there are certain ramifications, in particular with any of your retirement plans. So this is going to be your TSPs, 401ks, IRAs, 403bs, anything that is being funded with pre-tax dollars. And then you have these military survivor benefit plans. When somebody retires from the military, they can elect survivor benefits. And the individual can actually collect up to 55% of the military retirees' income or retirement income. And that too has to go into that first party special needs trust, subject to when the DoD adopted the regulations. It's just one of those things that they did. And essentially they looked at it as it's that individual's income. So it has to go first party S&T. Child support, I already said it's for the benefit, it's the child's benefit. And as a result, you have to put that into a first party special needs trust. And even more importantly, you can't by agreement agree to put it there. It has to actually be directed into a special needs trust by court order. All right, so there's a lot of what are called PLR regulations in here. Overlying concept, in December of 2019, Congress passed what was called the Secure Act. Before the Secure Act, we could actually stretch retirement benefit withdrawals over the course of an individual's lifetime, do what's called a stretch IRA. For a person without a disability, the rules have changed. You now have to pull it out over 10 years. And there's a couple other exceptions as well. But if you're an individual with a disability or chronic illness, you can still stretch things out. One of the big things that some organizations that I'm a member of, Special Needs Alliance, NALA, did was they actually heavily lobby to make sure that S&Ts would actually be included in the definition. And so it didn't have to go to the individual themselves, but could pass to a special needs trust and still have that stretch IRA. Once again, these are very complicated issues. And so attorneys and CPAs, CFPs, that's who you really want to talk about retirement assets with. This more about Secure Act, and there are what are called add-on bond beneficiaries. And so that's important to know that whenever I'm doing a trust plan, certain beneficiaries can actually destroy that stretch. So charities are one of them. And if I ever have a case where somebody does want to leave money to charity at the death of their child, then I have to look to charitable remainder trust for any qualified assets. And that's just because otherwise I have to withdraw it over a 5-year period. ABLE accounts. So these little creatures came out a few years ago, and they were touted to be like the end of special needs trust. I'm here to tell you they did not do that, and I use them for very limited purposes. So number one, you have to be disabled prior to age 26 to use them. Contributions can be made by anybody, but you can't actually receive more than $15,000 in a year as they were originally set up. We'll talk about a change that was made. And then if the account value exceeds $100,000, then SSI is actually going to be suspended, not terminated, until you fall back below $100,000, but Medicaid's going to remain unaffected. These things do have a Medicaid payback. So if I'm leaving money to my child, do I want to leave it in this account subject to a Medicaid payback or third-party special needs trust? Most people want to leave it in the third-party special needs trust. When you're making withdrawals, you do have to make distributions for disability-related expenses. We just got some regulations on this, and I've outlined in the materials kind of the different things that you can use this for. If you put too much money in a given year, then the contributions are going to make the ABLE account not an ABLE account anymore. And if you withdraw money for something not disability-related, it's going to be subject to a 10% penalty. We can now roll over, based on some a law that was implemented, roll over 529 education accounts into an ABLE account. So that was a big thing that I had experience with my families. All right, then we come to the Disabled Military Child Protection Act. Prior rules were that you had to leave your SBP to an individual. You couldn't leave it to a special needs trust. Lots of lobbying, lots of years. We can now move an SBP payment into a first party special needs trust. And so it's important to know for military families that there is this out here and there's some planning that needs to be done around your retirement for your child. Now, if you're federal or state service, civil service, the same benefits do not apply. We have not yet gotten to be able to clean up those rules to make sure that it could go to a trust instead of a person. All right, so I'm going to run through a hypothetical real quick, and then we're probably, we're going to use all these tools to see how it's fixed. All right, so we're not planning for Sally, that parents didn't do anything. Sally's working part-time, making $300 per month. So we have $300 per month of earnings take out that $65 disregard and divide it in half, essentially. So $117.50 is going to be counted against her SSI payments. So Sally's benefits are now reduced to $676.50. Sally lives at home with her mom, who doesn't charge her rent. Sally's benefit is actually reduced by $265, or 1/3 of that $794. So now her benefit's been reduced to $411.50. Theoretically, even if she paid like $50, it's not her full coverage, she would still have that reduction. Now she's also receiving survivor benefit payments of $500 per month. Sally's benefits are now reduced by $50 because we've already had one $65 disregard. Sally receives no SSI, and as a result, she's not automatically eligible for Medicaid. Her income would still be below a threshold. She's probably eligible. Actually, she would be eligible for waiver programs, stuff like that, but we're not going to get too heavy into that. All right, so here's the solution to the problem. All right, so Sally lived at home with her mom, who didn't charge her rent. And this is one of the big reasons why I use ABLE. What mom's going to do is basically the rent that daughter's paying, or Sally's paying, is going to get funneled into a third-party special needs trust. So that way it's safe, because mom never intended to charge rent to begin with. If her income is not sufficient, a special needs trust, that third-party special needs trust, or mom, whoever, will actually put money into an ABLE account. And the ABLE account can actually be used to pay for the food or shelter-related expense shortfall. The Social Security regulations, which are called the POMS, actually specifically says that an ABLE account is in the name of the individual. So it doesn't matter who actually put the money in there or how it was funded. But because it's titled in the name of the individual, it's not receiving food or shelter from somebody else. So there's no reduction. Sally's still getting $794 a month. Now we have that SBP issue. We put it into a self-settled special needs trust. She's receiving that $500 a month. There's no reduction in her benefits as a result of receiving that money. She's still getting $794 a month. Then Sally's working part-time and she makes $300 a month. Sally's benefits are still reduced by that $117.50. And so her ultimate benefit is now $676.50, and her automatic Medicaid eligibility, her waivers, everything's been protected. And that is it for the basic planning of special needs.
Okay, thank you. Next, we'll have Donna Roble.
Hello, everyone. My name is Donna Roble. I am a regional network coordinator for the Center for Family Involvement at Virginia Commonwealth University. Okay, so the Center for Family Involvement is, okay, so let's think of this as an umbrella. You have VCU is the umbrella. Under VCU is the Partnership for People with Disabilities. So I am part of an initiative out of the partnership, which is the Center for Family Involvement. So the partnership has many programs. It's been going since 1985. The partnership has been providing training and technical assistance to individuals, families, and professionals on best practices in supporting people with developmental disabilities and their families. And we include their website here. So these are some of the key initiatives that we have. You may be interested in the ACIT in College program. That's a great program out of VCU for individuals with intellectual disabilities. And they go to school on campus. It's a great program. That's one of our initiatives. And also the Center for Family Involvement, like I said, and I'm with. Okay, we can move on. Okay, so Center for Family Involvement, and this is, we're staffed by people with disabilities and family members of individuals with disabilities. We are funded by various state agencies. Here's a list of them. Primarily with the Center for Family Involvement, our largest funders are Virginia Department of Education and Department of Behavioral Health. Because we are funded by these agencies, when we assist families, there's no charge because of these funds that we receive through these grants with these state agencies. So that's, I always like for my families that I'm working with to know there's no charge for the help that we provide. That's why we're here, to provide you assistance and on behalf of these agencies. Okay, and this is our mission. So the main thing is that Center for Family Involvement and our Family Navigator program, our mission is to help parents gain the tools that they need to advocate for their loved ones, for their child, and to continue, and we even continue supporting these families once they're advocating and they're feeling confident. We're always here just to give you that extra little push. A lot of the areas, and there's another slide that'll include this, but we help families primarily with special education concerns, maybe eligibility. We help families navigate that they may have some medical issues going on, that they need help with finding medical providers in the area. We also work with families that are applying for the Medicaid waivers that Shannon was speaking of earlier. That's, there's definitely a waiting list for developmental delay waivers, but there's a waiver service, the CCC plus waivers, that there's no waiting list for those waivers. And so we have a lot of families we work with that are applying for them, or they already have that waiver and they're working on finding services using that waiver. So those are some of the how we assist families. Okay, again, that one-on-one peer support to families. We have materials to help families with special education, with the Medicaid waivers, helping them understand those better. There's our website, our Center for Family Involvement blog.org, where you can find more information there. So we are broken up into, or divided into 6 regions. And so all of the regions has a regional network coordinator like myself. And what we do is we have teams of family navigators. Family navigators are volunteers that have kind of walked the walk already, and they feel confident in their role as advocates for their loved ones, and they want to give back. And so, for instance, in my region, Region 6, I currently have 8 family navigators. So let's say I receive a call from a family that needs help with special education eligibility. They want to understand it better. So a lot of times I will help families with the special ed issues, but maybe I can't take it. So I will connect that family with one of my family navigators that has experience with the eligibility process. So they serve as your mentor and help you navigate that system. Again, there's no charge to the families. We can't call ourselves advocates. We are just providing that one-to-one peer support. So each of the regions in Virginia has the same team, same type of teams, where they have the family navigators that they match families that reach out looking for assistance. Okay, again, I kind of got ahead of myself on that. So these are the services that a family navigator provides and how they can help. That one-to-one support is so important, and in finding resources, but sometimes just having someone that knows where you are, that has already been there, and that kind of can validate how you're feeling. We have a one-to-one support, also including access to cultural brokers and disability-specific liaisons, which is very helpful. Okay. Our cultural brokers, again, are specific to immigrant, refugee, and/or racial and ethnically diverse populations. The primary role of a cultural broker is outreach to organizations and groups in Virginia. So that we have a great group of cultural brokers that even our navigators can reach out to as needed. If they have a family, to say, even a Spanish-speaking family, this happens real often. I do have a family navigator that speaks Spanish, which is great, but we also have someone on staff that's always available to help with our Spanish-speaking families. Okay, again, there's our top request for support, navigating those systems. Medicaid, that's a big one. We work with Department of Behavioral Health. We help with the Individual Family Support Program. We host meetings for them every other month. Even down to finding, this time of year, I start getting those calls from parents that are looking for camps, for instance, for their child with disabilities. That's not always easy to find, and the funds aren't always easy to find as well. So we kind of help them navigate finding those things. Transition, that's big. We have our program that, and actually I do a presentation on supported decision-making and alternatives to guardianship. Shannon gave a great presentation on that this evening, but we do help families with transition as far as, you know, finding the resources and finding answers that they need in a lot of cases. And again, the Medicaid waivers and healthcare and care coordination, we assist families there too. So that's kind of it. I will include my email address in the chat. If you have any questions about our program, if you're in need of assistance, if you want to share our information with someone else that may benefit from this support that we provide, please feel free to reach out. And thank you for having me tonight.
Okay, thank you. I can't believe we don't have any questions really, but Sharon, there is one in the chat.
Yes.
For Shannon, can you ask that?
Sure. Shannon, the question reads, can you explain the differences between an ABLE account and a special needs trust? Is it true that any money left in an ABLE account at the time of the disabled person's death must be surrendered to the state to repay public benefits?
So yes, and you know, I kind of broke down two different trusts. So if I am talking about a first party special needs trust and an ABLE account, they are both subject to Medicaid repayment. The rules for that repayment are going to be a little bit different. First party S&Ts, like I said, is that lifetime accumulation of benefits, whereas ABLE accounts are only from the time that the ABLE account was actually established. So there's a little bit of funny rules with regards to that Medicaid payback. When I'm looking at the third party special needs trust, there is no Medicaid payback, so that goes away. The big difference though between special needs trust and ABLE accounts are going to be third party S&Ts or any special needs trust, you can put any amount of money in them. Whereas with the ABLE account, you're limited to that $15,000. There is this a law that was passed that will also allow you to contribute personal earnings to it. It doesn't eliminate the fact that that's earned income to reduce SSI, but it allows you to save a little bit more. I can also have $1 billion stuck in a trust and it doesn't disqualify me for benefits in any way, shape, or form. In an ABLE account, once it goes over $100,000, it will actually be subject to the loss of SSI. It's suspended, not terminated. And then the state has also imposed, every state has a different limit, but there's also a max contribution. So I believe Virginia is still at $300,000. You can't contribute more than $300,000, but you can only contribute in $15,000 increments. Special needs trusts are for anything that's not otherwise provided for by public benefits. And each of the terms are going to be a little bit different. Everybody drafts their trusts a little bit different. And so really the rules of the trust are going to comply, but in big picture language, a special needs trust is for anything public benefits doesn't otherwise provide for. Whereas an ABLE account has to be for qualified disability related expenses. So in terms of how much it can get funded, both from a lump sum perspective and totality, they're going to be different from the distribution rules. They're going to be different. The Medicaid payback status might be different. And then also the funding or the disability ages. So third-party S&Ts, I can have a disability age 80 and, my spouse could leave me money in a special needs trust, or, and has to be testamentary. So that is a rule for spouses. But for an ABLE account, your disability onset had to be prior to age 26. So there's lots of different rules. They are not apple to apple comparisons at all. There's another question that came in. It says, Shannon, if my child has money in a savings account, should this be moved if it is under $1,000? So it's total assets. So if they have $1,000 sitting in one account, $1,000 in another account, $1,000 in another account, then you are going to have to do something with that money. The general rule for both SSI and Medicaid is going to be you need less than $2,000 in total assets. I did have a client that got in trouble with this because they had savings bonds in addition to the bank account, and they were literally over by $10 and had to repay back benefits.
Wow.
Yeah, a penny over will disqualify you. It's a hard and fast rule.
Shannon, we also have another question. It says, could SSDI be reduced due to earned income or assets after age 18? And just in parentheses, parents passed away when disabled child was 6.
So SSDI, you will continue to collect as long as you are not disabled, or as long as you are disabled. The only time you're going to lose it is if you have that substantial gainful employment issue. So it's like, what is it? 1310, I think is the new number. I always have to go back and look at them. So as long as you're not able to make that amount, you're fine. SSDI is not income tested. It is not, aside from the substantial gainful employment piece, and it's not asset tested. So it will not be reduced.
Okay, we have another question. It says, I was told I have to get custody instead of power of attorney of my sons once they leave high school, and it costs $5,000 per child. Is this true? So
this is actually what's called the Guardianship and Conservatorship and power of attorney. Whenever I was presenting, the big thing is what's the capacity? So the first question I ask anybody coming to my office is, okay, yes, what's the diagnosis? But tell me about your child. A diagnosis alone doesn't tell me about your child. I have been working with individuals with disabilities since I was in high school. So I'm very much more aware of the diagnosis doesn't tell me much. So question is do they understand the power of attorney? And if so, and they can sign it, great. Then we don't need to look at guardianship conservatorship. Now, what I will tell you, though, is that I still do have some families who say, well, my child is very susceptible to exploitation. I see this a lot with my families that may have an individual Down syndrome in particular. They want to make sure that they're empowering them as much as possible, which I completely love. But then they're like, if they're out mingling with the general public, I'm just really afraid that somebody might present them with a contract or, something that they shouldn't sign. And so sometimes I still do have families who want that protective nature of a guardianship. And also just know that a guardianship doesn't necessarily mean that all rights are terminated. Voting, for instance, is a big one. And usually even on our doctors' forms, we have the doctors opine, does somebody have the requisite capacity to still engage in certain activities so that we're not completely stripping away every single right that the individual has. Cost for guardianship, I will tell you, is a multitude higher than a power of attorney. The reason why is we have courts. If we're stripping away people's constitutional rights, the Fourth Amendment, right to due process, the same right that's attached to a criminal defendant attaches in these proceedings because somebody is no longer going to be able to make decisions for their own life and liberty. And so as a result, I have to dot I's, cross T's. The courts definitely want to see stuff. So $5,000 is the going rate for a guardianship. Now, that said, our office usually combines them, or I do. I can't speak for all the attorneys in my firm, and try to reduce it to kind of alleviate some of that from the family. But $5,000 is the going rate for the vast number of guardianships in the area. Sometimes, too, what I have seen is that there are some attorneys who dabble in this and they might reduce their costs, but they're not going to know to put special needs provisions in. So like the ability to fund special needs trusts, things like that. maybe some of the gifting powers or even using ABLE accounts. And so sometimes you pay twice as much just merely because you haven't, you might have gotten a reduced benefit on the front end, but not on the back end. All right, so I know Donna, and I'll let you speak on this more, but as of right now, surrogate decision-making is up at legislation or up at the General Assembly. It has not passed. Special needs advocates from the attorney's perspective feel like the law still needs to be expanded upon. So as of right now, powers of attorney and advance directives are the legal means to do it. Supported decision-making, whereby like we have these micro board, we don't have any laws on it, but I've seen micro boards get put in place, and then just, general assistance without maybe the legal authority to do it, and then your guardianship. So that's really all that's in place right now that I've seen. And the micro board concept is you set up a corporation, and the corporation helps an individual make decision through a supported decision-making program. But Donna can definitely speak more on the supported decision-making and the advocacy stuff that they may be working on there.
Donna, are you? I don't think Donna's here.
Okay.
Okay.
Donna's still on. She's still on. I just don't think she may have stepped away for a second, but she's still
Okay.
on.
Oh, okay.
I see that Latasha Brown said she wanted more information on the ACIP program. I can't speak to that.
There is one. I missed this. When my child turns 18, should I sign her up for SSI?
So as long as they are disabled, which means unable to maintain substantial gainful employment, it's definitely important to make sure that you're getting their disability determination prior to age 22. So one of the things I touched upon is that if you have that disability determination prior to age 22, they will latch onto your benefits, which to me is a big benefit in the long term. So my recommendation is to apply as soon as the child turns 18 and get that disability determination.
Okay. I guess
We do have a few more. Shannon, one says, what are the alternatives to guardianship that Donna Roble referred to? So
yeah, I touched upon that. Technically right now, the only way to have legal authority to make decisions for somebody is through power of attorney or guardianship. We have these micro boards that are a supported decision-making alternative. So it's essentially a corporation, non-stock corporation. And it's designed to create a system of support for supported decision-making, but it doesn't actually give somebody the legal authority to make decisions on behalf of somebody else. There's pending legislation in the General Assembly now on support. It's a supported decision-making act. And the legal bar right now wants some more build out. And I think it might've been referred to the Graves Commission. But essentially we're afraid that without some sort of oversight that an individual, because there's no, like you either have capacity or you don't, right? And so that's kind of our fundamental thing is either you can do powers of attorney or you can't. And so our concern is that there's going to be a lack of oversight for maybe marginal capacity issues. And so there's just a lot of problems with the bill as it's drafted right now from a legal practitioner standpoint. That said, I will be the first to say if we can find something to be the least restrictive, I am all for it because I'm very much one of those people to try and empower independence as much as what we possibly can.
And I did notice that Donna did, she put in the website for ACID in college. So if you're interested in that website is listed in the chat.
I see there's another question. When is the best time to start planning? My son's in the 5th grade. What should I do? Well, everybody over the age of 18 should have some basic planning put in place. So your child will not be able to do any planning until 18 for themselves. So if they can do power of attorney, advance directive, whatever. So number one, you need to have your documents as soon as you turn 18. Otherwise, and I just say a simple car accident. I see kind of some of the worst cases out there. My poor kids probably are not going to have a real life because I'm not going to let them go to carnival rides and all the other fun stuff because they see all the bad stuff. But you get in a car accident, your spouse just can't make decisions for you. So I'll use real property as a prime example. You may own that property with your spouse. You're in a car accident, traumatic brain injury. You can't make a decision. He can't sign your name to sell the house. So powers of attorney, advance directives, imperative now. Also, then if you were to die, what would happen? If you know that your child is going to be disabled at age 18, getting those trusts put in place now is imperative. You cannot do a guardianship though for your child until they're 17 and a half if you need to go that route. That's the earliest I can file. So planning sooner is always better because we never know what's going to happen. But then also, sorry, my computer is showing a text from my mother. So the other thing is that if you wait until your child's 18, there could be a multitude of different things happening. So a military retiree, they're retiring and they need a first party special needs trust. They're now looking at how you leave an inheritance and the third party trust and their own estate planning, plus a potential guardianship for their child. That bill could be huge. So trying to space things out usually works best for my families too.
Okay.
So be proactive.
There's another question. How do I get disability determination?
You have to file with the Social Security Administration. So you can file an application online. I actually don't think Social Security is meeting with anybody live right now.
Yeah.
I haven't heard that change. So basically file online and walk you through it. What I will tell you is an attorney will not help with the disability determination, the initial application. They are only going to help with the appeals. And that's because the Social Security Administration has iced us out. And so that's just important. I do get a lot of families to call. We actually don't help with Social Security applications, but we definitely know people who help in that arena.
Another question, did you say that guardianship would expand to another state?
No. So if you want to move somebody from state to state, you have to have authority. And we do have what's called the Uniform Guardianship Jurisdiction Act, and it's actually more formal than that. But so once somebody relocates to another state, you technically need to transfer it or otherwise domesticate that order as a foreign judgment so that that state recognizes it. If I want to move, what I was talking about though was different jurisdictions. I have to get the court's approval. It's a hot power to be able to move somebody out of state. So if I want to move them out of state, I got to get permission from the court first. Most jurisdictions, it's pretty easy. I just put it in there. Your mom and dad, why can you not move the kid whenever you want to, right? They're moving with you. But in Virginia Beach in particular, the issue becomes the judges want to know when they're moving and where they're moving to. And so Virginia Beach is one of my jurisdictions that I cannot just willy-nilly get the authority to move from state to state. That is a specific hot power.
Wow. I think that's it. That's all of our questions. I do want to thank you, Shannon and Donna, for joining us tonight to talk about future and financial planning for students with special needs. Very timely, full of information that anybody can benefit from. This concludes our webinar. Thank you to, I do want to thank the transition specialists and from Chesapeake Public Schools for collaborating with us to provide this webinar. If you have any questions regarding transition and support, contact the transition specialist for your school. This webinar has been recorded and will be uploaded to the Chesapeake Public Schools YouTube page within the next several days. Thank you for joining us this evening. And remember, families and communities work better together.